You may recall in an earlier blog I spoke about alternative dispute resolution and how your attorney will be asked whether he or she is amenable, that is responsive or agreeable, to alternative forms of dispute resolution. I spoke about mediation very recently and the kinds of the perspective that the mediator offers to you at the outset of the mediation. But what about arbitration? And arbitration, when the parties agree, becomes binding with a very limited right of appeal. Well, arbitration has been criticized and heavily in recent months, and there was a three-part series in the New York Times this past summer and fall which dealt with some evidence and anecdotally of how unfair arbitration can be. And I'm sure there is truth to that, and I'm not always a big fan of arbitration. But let me suggest to you, since it is a form of alternative dispute resolution, 4 reasons why people are advancing arbitration, 4 reasons why they will tell you that it is advantageous to engage in arbitration. First, there is no question you will find a time savings element to it. There need not be quite as many depositions prior to the arbitration as there would before a jury trial, and litigation costs will therefore be reduced. And likewise, you may not have to bring the same number of experts who charge money to an arbitration, whereas before a court, you may well bring those experts. You also have a right, along with your adversary, to select the arbitrator or the arbitration panel if there's more than one. And certainly your lawyer can try to select somebody who will treat you, the litigant, the person going to the arbitration, in a fair way. Thirdly, there's convenience and efficiency to the process. It happens rather, it can be scheduled in a quick way, and the hearing itself is usually of a much shorter duration than the hearing would be, than a trial, a jury trial would be. And there are many reasons for that. And then there's an element of privacy, because an arbitration is held in a private office where the arbitrator has space. The arbitrator could be a retired judge, or it could be an experienced lawyer in their private law office, and that or the arbitration services office, and it is in a room. It is not in an open court, and there is no publicity attached, and people are not walking in and out of the arbitration room as they can in fact be walking in and out of the courtroom. So I would say those are the 4 major advantages of arbitration, though I don't mean to suggest that it is necessarily the best route in all cases or in all situations. But it does have 4 things to commend itself. Thank you.